You're listening to Southeast Radio's Business Matters with Karl Fitzpatrick in association with Wexford Insurances. Challenge us at Wexford Insurances 0818 31 30 30.
Welcome back to Southeast Radio's Business Matters with me, Karl Fitzpatrick. Earlier this week we saw Minister Shatter securing government approval for the general scheme of a mediation bill. And in studio now to join me to discuss this is Patricia Stafford from Y Mediation. Good morning, Patricia, and thank you very much for joining me this morning.
Morning, Karl. I'm glad to be here.
Patricia, before we discuss the mediation bill itself, tell me a little bit about your own background firstly, please.
Well, I suppose my background in the last quite a number of years has been in property and property-related matters, rental properties and property sales with Kehoe's here in Wexford. And during the process of my involvement in that, the Residential Tenancies Act came into play, and as part of that, they started up a dispute resolution sector, and or section, I should say, and I became involved as a mediator, initially as a mediator, and over a period of time as an adjudicator with them in tenant and landlord disputes, generally related to issues concerning the end of tenancy, returning of deposits, condition that properties were left in, etc., etc. So that's what got me into mediation, and it was what began to intrigue me with the process.
So your time in the PRTB gave you that eureka moment that would then allow you to say you felt that there was an opportunity on a broader scale to set up Y Mediation. I suppose firstly, before we speak about your own business, for those that aren't familiar with mediation, what's it all about?
Well, mediation is really... I suppose in order to describe what it is, you have to describe what a mediator will do. So a mediator, in a way, is a facilitator, and he sits between two people or two lots of parties, and they facilitate them in discussing it. So it's a kind of like a facilitated negotiation, really. And the mediator is like the orchestra conductor, for want of a better word, where they draw the story out. They allow it to be heard by one another, more importantly, and they root out the issues and make sure that they're all fully explored and discussed in order to clarify things, to check the realities of people's perceptions, and to I suppose develop a sense of empathy between parties for the resolution of disputes. And it really is all about the resolution of disputes. It's a confidential process by nature, which means that what happens within the mediation doesn't extend beyond the mediation. And participation in it is generally regarded as being voluntary. Certainly, the courts have a tendency and an intention in the future to mandate people into information sessions about mediation, but you really can't mandate participation. Participation must be voluntary.
And how does the process work?
The process works, I suppose, and again there is a certain amount of magic involved in it, where I suppose it depends on really what process you're talking about. So you can break it down. There's quite a different process for family mediation. A family mediation is regarded, when we say family mediation, we're actually talking about facilitating the breakup of marriage.
So, Patricia, mediation is a broad-based term, and I suppose it can be used across a myriad of areas, from civil disputes to commercial and to family disputes. But for the purpose of today's interview, I want to focus particularly on workplace disputes. Tell me how the process works within the workplace.
Well, generally in the workplace you're called in because there's been a complaint made by an employee to the HR department that the HR department are having some difficulty in dealing with themselves. Ideally they would deal with it in the first instance in-house. Sometimes then they think, well, we can't resolve this, we're having difficulties with it, we'll bring in a mediator and get them to sit down between the parties and work things out. Generally the complaints, as it starts out, the complaint is relatively small. The trouble is that if they leave it to fester, it will escalate, and they become aware of that. And good practice is early intervention.
And in relation to the benefits attached to mediation, what are they?
I suppose it's about keeping the employees happy, really, in many cases. If you have a complaint, if an employee makes a complaint about another employee and it's not addressed, you get a kind of a festering. You also get what would be sort of a gathering of constituencies around either the person who's making the complaint or indeed the complainant, and as a result the whole workplace becomes infected. So by dealing with the one problem, you generally are heading off bigger problems down the road.
So really what you're saying is that early intervention is key, Patricia. Tell me, from your experience, what are the main causes of conflict in the workplace?
It can be almost anything, really, but conduct, the way people behave in the workplace. It can be work performance. It can be to do with supervision, under supervision, over supervision. It can be to do with sickness and absence that's relatively unexplained. It can be to do with relationships in the workplace that break up, romantic relationships now, I mean. Theft, accusations of theft, fraud, accusations of bullying and harassment, discrimination, a myriad of problems. But generally speaking, they're small things. They start out as very small things. And I suppose that's why my focus is always on early intervention. It's much easier to get in and deal with the problem while it remains small.
And in relation to the Mediation Bill, which is expected to be published maybe in the next sitting of the Dáil, I'm sure that you're in favour of that coming through. But what are the big objectives of the bill itself?
Well, I suppose the main objective of the bill is to bring mediation into the mainstream, because it has been out there on the fringes for quite a long time, and it certainly has been widely used in commercial matters, for instance. And we would be familiar with seeing judges asking, litigants to leave the court and go out to mediation. And one of the prime examples of that would be the Kenny Charlton case, the case with Pat Kenny, where he had the boundary dispute with his landlord. And it went out to mediation, and in one day a matter that had been going on for years was resolved. And I suppose the wonderful advantage of that was that although we all would have been dying to know what the outcome was, actually in the end none of us did, because mediation is a confidential and private process. It takes the dirty linen, for want of a better word, out of the public arena, and you wash it privately. It's from the point of view then of a business. It just means that you have reputational issues. You have all sorts of things that aren't rehearsed in a courtroom. It's all done privately in house.
And will this particular piece of legislation see solicitors having to make their own clients aware of using mediation as an alternative means of resolving disputes prior to commencing court proceedings?
Yes, they will. They'll be obliged by the law now to do it. There was always a kind of a certain obligation on solicitors, and largely they complied with that to advise their clients of the opportunity and exactly just to tell them even what mediation was, in order that they could choose to either use it or not. It was something that I suppose what's going to change now is that they're going to have to certify that they have done so.
From a practical perspective, Patricia, give me an example of a workplace mediation that you've previously worked on.
Well, I worked on a case recently with a colleague in another part of the country to do with the mobile library service, where a young librarian travelling in the library began to feel that she was being sexually harassed by the driver of the bus of the mobile library. It was. We were brought in because clearly there was a big issue, and she was talking about leaving her job, and it became a worry for her superiors. So we were taken in, and we sat down with both of them. And first of all, the young librarian, told her story in the presence of the driver. And I could see clearly she was very distressed, but I could see clearly by the driver that he really didn't know what she was talking about. And over a period of time and through the interview with her and through her talking, he began to you could see it clarifying in his mind that what she was saying, she wasn't telling any untruth, but her perception, he thought, of what went on was so different to what his perception was. So at the end of the day, what turned out to be an accusation of inappropriate touching and, handling, to him was just jolly banter and, a bit of crack on the bus, he began to realise was inappropriate. And over the course of the day, he said, I'm beginning to see that it was inappropriate. It wasn't inappropriate for me because I wasn't thinking anything. But clearly, he said, it was interpreted in a different way. And I really am going to have to watch my behaviour and modify my behaviour. And I'm really sorry if I caused any distress. Now, the interesting thing about it is that quite a lot of work-related issues are small issues. And they inevitably finish up with an apology of some sort. And sometimes with both people apologising to one another.
Now, what cases and what situations does mediation not work?
Mediation won't work where there's illegality. You really can't mediate an illegal act. You really have to abandon it at that stage. And it's within your right to stand up at any stage and say, I can't do this. You really, according now to the bill, you're going to have to explain why you can't do it. Previously, we felt we could just say, look, I'm not going to do this. I'm just not happy to do it. But now we will have to say, and this is why. It's very important in family cases in particular where there's any suspicion of child, issues to do with children, that you don't try and mediate something that is dangerous for a child or dangerous for another party. So there are times when you'll walk away. There are other times then where if you cannot get a client to open up and to put the thing on the table and to be honest, and you can't build a trust relationship with them, you clearly can't proceed, because you are very dependent on the parties and the goodwill of the parties to put the issues out on the table.
And what's the average duration of a mediation?
Well, in the workplace, the mediation normally would take about a day. Hardly ever will a mediation go beyond a day unless there are very, very serious issues. Generally speaking, it would be where you would take the complainant usually first and go through the case or her particular case over a period of a couple of hours, we'll say in the morning session. The second part of that morning would go to the person against whom the complaint was made, and again you would go through quite some detail the story with him. And then in the afternoon you would bring the two parties together in order to almost actually go reiterate the whole story again, to allow themselves to hear themselves tell it to the other person, and to allow the other person to hear and to understand what the pain is and where it has come from. And generally that final session will take anything from 1 to 2 hours, and at the end of it, in general, you can say, this is done.
Patricia, am I not right by saying that the Labour Relations Court was set up specifically for employees or employers to be able to take whatever indifferences and whatever disputes that they had between each other into a labour-related court and keep it out of the standard district commercial courts? So on that basis, what's the difference between mediation and the Labour Relations Court?
In some ways there are no differences, and in other ways there are. The focus generally, in people's minds anyway, is that the Labour Relations Court deals with what would be employee rights. That isn't necessarily so, because they also have mediation available to employees through the LRC and indeed the rights commissioners. That is now actually under review at the moment, and they're currently working. There's a pilot programme actually going on to do with mediation within it, but they're working towards creating what will be one body, which will be the Workplace Relations Commission. The difficulty for employers, beg your pardon, in recent times with the LRC has been just literally speed of access, trying to get in there. They have a problem today. They want it resolved today. They really don't want to have to wait 3 or 4 months. Now, the changing over to Workplace Relations Commission may actually alter that, and you may find that the process becomes more speedy. So what I'm finding is that when an employer hits somebody outside who comes in, resolves his difficulties for him speedily and well, he's happy enough to go there. An awful lot of the issues taken to the LRC would be more rights-based matters to do with labour relations, to do with wages, conditions and that sort of thing. The focus of mediation is more on the needs and interest base, so it's to do with the things that I suppose in a way make your life worth living. and are to do with just feeling more comfortable in the workplace rather than absolute rights.
Okay, well, Patricia, I'd like to take this opportunity to thank you for coming in and discussing the entire topic of mediation with us today. It's certainly a very interesting topic and certainly a practical solution and alternative for employers across County Wexford. I wish you continued success with Why Mediation. Thank you.
You're listening to South East Radio's Business Matters with Karl Fitzpatrick in association with Wexford Insurances. Think Wexford Insurances for your business insurance.